So what is an original petition for divorce in Texas? Well, that is the document that needs to be prepared. Even in the most agreeable of circumstances, somebody has to fill out a document or hire an attorney to help them do so. And that document essentially says, this is who I am, this is who my spouse is, identifies the children. The most important thing in there is that you have to spell out to the court that the court can take jurisdiction over the marriage or the children because one or both of you have lived in the county for you have to have lived in the state of Texas for the previous 6 months, and the county where you're filing suit for the previous 90-day period. This is a jurisdictional requirement that can bounce a case, and it's a tough one because sometimes people are coming in from out of state and their residency requirements, or they're worried that their spouse will go out of state. Again, concerned about residency requirements, leaving the state, coming to the state, and it is the residency jurisdiction requirement is one that you got to be absolutely sure of. There are a few exceptions to the residency requirement for certain kinds of emergencies. The court can take emergency jurisdiction if there's a chance that the kids are going to be removed from the state of Texas and put beyond the reach. In other words, if there's some danger of international travel, and as long as there's no other court with ongoing jurisdiction, the judge can do something about that. But that's a rare situation. Other things that can go, not always required to, in an original petition for divorce are things like protective order applications and restraining order applications, where a client can ask the court for additional protections that go above and beyond the standing orders. And those standing orders are not in every county, but in most county. And there's within those standing orders restraints and prohibited conduct that is immediately, locked out upon the filing and service of the original petition of divorce. So one of the things that happens is that a spouse doesn't always have to ask the court for protection for restraint from abusive or harassing behavior. Many counties, more and more, it's really the exception now when a county doesn't have a standing order, that you don't have to have a restraint on harassing behavior, on shutting off finances, cell phones, things of that nature. Even though those prohibitions are generally contemplated within the family code, they're not part of every county's standing order. Tarrant County being an example of that. So Fort Worth the last time I checked, doesn't have a family law standing order, and every party there has to make an application for restraint from shenanigans with the money, with the cell phone, with the car payments, with that water bill at the house, the cable bill, to make sure those things don't get shut off, where a standing order takes care of all that. And then, of course, a protective order is for situations where there's some threat of family violence to a family member, somebody in a dating relationship, something like that. Has to be recent, has to be able to be articulated, have to show that it's happened in the past, likely to happen in the future, such that somebody has to be restrained or excluded from the home. It's a pretty high burden, but can be met. But these are the factors that go into an original petition for divorce in Texas. These components are what need to be thought about, included or not included. And, if you're lucky enough to be in a county with a standing order, sometimes you don't need to ask for restraining orders, protective orders. The standing orders alone are enough. Anyway, questions or comments, chat@ashmorelawfirm.com, chat@ashmorelawfirm.com.